My name is Don Slavik. I'm the Executive Director of the United States Police Canine Association. What you're looking at today is the work of the USPCA Best Practices Group, made up of many people from around the country at all levels, from trainers to police chief. We search every day, email amongst each other, everything that's happening in the United States. We look over case law, we look over deployments, we make recommendations on what we think is the best way to go to the people in the USPCA and people that get our emails. So that's what we do. So last year was the year of the supervisor. We did 5 videos for supervisors of K-9 units, some of the things they should know or want to know. This year, Gene Ramirez is going to be our main speaker, talked about the idea of having someone being able to testify as an expert and what that entails. We are going to have 3 webinars that talk about how you should prepare yourself, the things you can say and do while you're in court, and the things you should do. David Ferland, retired chief of police from Portsmouth, is going to be our moderator.
Welcome, everybody, and thank you for coming. I just want to give you a reminder. Don't forget to put this down as part of your training log. This is important that you document this type of training, and it also gives you credit for having a 90-minute training block here. This is the first of 3 parts, and I just want to say thank you for inviting me to be part of the best practices group, Don, and also to be part of this presentation that we're about to give. Here's the rest of the best practices group. Before we get going, it's important that we just notice who is part of the USPCA best practices group. We meet every week. We talk about different things that are occurring in the industry. We decided that this year we needed to focus on testifying. Gene is an expert at this. We have several others. Steve White, Scott Sargent have all testified as expert witnesses as well. And everybody else on the best practices group has testified as a dog handler, a dog trainer at some level. So we are bringing a lot of experience to this topic today. So thank you very much. Our featured speaker today is Gene Ramirez. Gene is a founding partner in Los Angeles of a law office called Manning Cass. He is the leader of constitutional policing and government entity. Gene has many accolades to include Attorney of the Year, California Lawyer of the Year. He testifies and prepares cases for the California Association of Tactical Officers and SWAT teams across California and the United States. He was a trial attorney for many years. He is the go-to guy when your case needs the highest level of a attorney representing you and the case that your department might be in. Not just police K-9, but use of force incidents. Gene has been with the United States Police Canine Association for many years. He's been our attorney. He is the one that prepares our cases for briefings to various state level courts, to the United States Supreme Court. He is the one that renders our legal advice when it comes to the administration of the USPCA, but also the cases that come to the USPCA. So, Gene, I'm going to turn this presentation over to you. Gene prepared this as a lesson plan. I put this together as a PowerPoint presentation along with the rest of the best practices group. These next 3 parts that you're going to have this month, next month, and the month after are primarily Gene as the lead spokesperson for this. Gene, welcome. I'm anxious to listen to you again.
Well, good morning, good afternoon, depending where you are. Thank you, Lou. This is a fascinating subject. I so believe in preparing law enforcement officers for training. In my firm here in LA, we have 4 floors. One of our floors is actually a mock courtroom set up to look like a federal courtroom. When we prepare our officers and deputies for depositions, particularly for trials, we use our mock courtroom, and their attitude subtly changes to now they realize this is serious business, and a lot of them are not prepared for that. You're expected to know quite a bit as a law enforcement officer. Part of that process is you have to know use of force, when to apply it, when to not apply it. You have to know how to write a report. And I think report writing is a crucial skill to master because that goes along with later testifying. I have had use of force reports that I've read where the use of force is marginal. The author wrote about it in such an intelligent manner, proper punctuation, grammar, spelling, that all of a sudden that marginal use of force looks much stronger. Likewise, I've had some very good uses of force marginalized because our report writing skills weren't that great. I'm a big proponent of report writing skills, and that may be a seminar down the road. But then part of the process is once you write your report, you may have to defend that use of force. And it's going to be in one of two venues, criminal court or civil court. So let's talk about criminal court. Criminal court's a little different. A lot of you have testified in criminal court. It's a little more relaxed in the sense that people look upon you as the savior. You get to come into court wearing your uniform, you got your gun on, you get to sit next to the jury. If you're the investigating officer for the prosecution, sits close to the jury, and the jurors are looking at you like, okay, you did something good and we want to support you. And you get up there and you testify, and it's usually not that difficult. Civil, however, is a completely different ballgame. First of all, you're not allowed to wear your uniform in civil court. Most of the federal courts do not allow you to walk in with a gun. For some of you, that's one of the most important identified features of your life, is the fact that you get to carry a gun. And now you walk into a federal court, you're not in uniform, so you already feel uncomfortable. Then they take your gun away and you check it in with the U.S. Marshals. Now you're feeling naked. Oh, what am I going to do? I don't have my gun. I'm already nervous. Then you walk into the courtroom and you realize that you are not going to sit closest to the jurors. On the contrary, you sit at the table furthest away from the jury, and it's the one that has a little sign on it that says defendant. You look at that and you're going, wait, defendant, isn't that the guy I just arrested a couple of months ago and testified against? Isn't that the guy that goes to jail? Isn't that the bad guy? All of a sudden, your mind is playing games because now you're saying, I'm the defendant. And the person that you arrested and used force on, they get to sit closest to the jury. That's just not fair. And then the judge is going to tell the jurors why we're there. That we're here under 42 United States Code Section 1983, an excessive force case. Now the jurors are looking at you and they're going to find that a dog is involved and they say, oh my gosh, are you one of those cops that misuses their dog? Maybe it's a wrongful death case where you had to shoot and kill someone. If race is involved, they're going to look like that you're a racist murderer. And that's how you're going to feel as the judge is reading what the case is about. And the jurors are looking at you like, why are you sitting behind the defendant? So psychologically, you're already behind the 8 ball. And now you can be called by the plaintiff's attorney first as an adverse witness. So you're going to be the first witness called and they're going to go after you. It's all going to be cross-examination. How well you testify will dictate how well we do in that case. I've tried 49 cases in state and federal court. I've tried criminal and I've tried civil cases. One of the things that we've learned is that jurors will come back in your favor if you come across as credible, likable, believable, your craft. And I'm going to talk a lot about knowing your craft. That makes a difference in winning or losing. However, if you come across as maybe you're a great cop, but got a really bad day, we're going to lose. If you're not credible, if they don't like you, if you don't know your craft, the chances are we're going to lose. We have something that we're now experiencing called nuclear verdicts, and we also have nuclear settlements. The nuclear verdict started with the trucking industry and the pharmaceutical industry, where jurors will return $100 million verdicts against Johnson & Johnson or Swift Transportation because a truck crashed and killed a family of 5 or whatever. Anything above 10 million is regarded as a nuclear verdict. Everybody thought, oh, that's products liability, that's trucking, that's pharmaceutical. It's now in the law enforcement world. City of Dallas recently lost $100 million against an officer drunk, entered the wrong apartment thinking it was her, saw someone in her apartment, not realizing she was in the wrong apartment, shot and killed that person. She's now serving 10 years in prison for murder, and the jury returned a $100 million verdict with, I think, 30-something million punitives against that officer. We're seeing these large verdicts. LAPD recently, 23.8 million in a shooting case found against the officers, 12.8. So we're seeing multiple verdicts above 10 million now. We have the nuclear verdicts against law enforcement. And a lot of it comes down to how well do you testify. We talk about being an expert. In reality, this is the class on how to testify. Because when you're up on the stand and you're the one that used the force, the jury is going to look upon you as the one that has the most knowledge. You are the one that knows why this occurred, how it occurred, and whether it should have occurred. So you have to answer those questions. It used to be you were trained, we're going to answer questions a certain way. Yes, no, I don't recall, I don't remember, and maybe a short answer. We have to change that line of thinking now because it's what's called reptile litigation. And reptile litigation, again, is the subject of another class. But basically, reptile litigation means that the plaintiff's attorneys try to appeal to the jurors and they try to scare them into saying, oh my goodness, if I rule against the plaintiff, society is going to be worsened. It's going to be weakened by allowing the defendant, the company, the law enforcement, the municipality, whatever it is, to continue what they're doing. And you will know that you're involved in a reptile litigation case during your deposition. They're asking you questions like, would you agree that you should not use excessive force needlessly? Would you agree that you should not needlessly train people to do things that are wrong? When you start hearing words like necessary and needlessly, you know that the attorney on the other side is engaged in reptile litigation and is going to use that against you in a court of law. We've changed the way we train our officers and our deputies. If they ask you a certain question, we call it a list question. For example, tell me about all the training you received on the Fourth Amendment. That's a list question. You should go back to your days in the academy. Starting in the academy, we learned about the Fourth Amendment. And then in my FTO program, I worked with my FTO officer and we talked about the Fourth Amendment. I have taken advanced classes on the Fourth Amendment. Up until today, we are learning on the Fourth Amendment. So that allows you to just open up all your training and you should be very well documented. One of the things we'll talk about is your resume. How current is it? Are you documenting all of the training? Lou mentioned at the beginning of this presentation, document the fact that you're here 90 minutes. And what is the Fourth Amendment? Everybody should be able to spit that out. That is knowing your craft. Everybody has the right to be free from a reasonable search and seizure. If you're into tattoos, tattoo that on your left arm. So if you forget, just look at it. Everybody has the right to be free from a reasonable search and seizure. You're good. But you just have to be able to spit it off the tip of your tongue. And those are kind of things that we talk about. Testifying also involves, it's a game and you have to know the rules. And the more you do it, the more proficient you become. It's just the number of repetitions, number of K-9 searches you have, the number of times you serve a search warrant. You become more comfortable and begin to understand the rules of evidence and the rules of the court and how to respond to opposing counsel's arguments. Now, we try to help our officers learn certain things and our deputies. So we sometimes give mnemonics. We call it Dave PP, DAVEPP. So they will ask you, what did you review to prepare for your testimony today, either in trial or deposition? You're nervous, you get 12 jurors if you're in state court. If you're in federal court, you get 8 jurors. You got a judge, you got people in the gallery, they're all looking at you. And all of a sudden it's like stage, oh my God, what did I review? If you remember Dave Pepe, D for documents, A for audio, V for video, E, any other evidence, P, policies and procedures, the other P, photographs. If you remember that, you're going to say, okay, yes, I looked at my policy. I looked at my body-worn camera video of the incident. I looked at my use of force policy, my K-9 policy. I looked at photos of the suspect, the injuries, where we located him. Any other documents? Yes, I reviewed my partner's supplemental report. I read the primary report. So that kind of calms you down. Okay, I can answer this question. In another one of these sessions, we'll talk about how you have to have a Zen posture on the stand, how you receive the question, think about it, giving your attorney a moment or two to determine whether they're going to object or not. And then if no objection, you're allowed to respond. So you got a split second there to figure, okay, how am I going to respond to this question? There's different kinds of witnesses. There's going to be the fact witness. That's you. You use force. So we're going to ask you what happened that day. Why'd you deploy your dog? How long was the dog on the bite? How soon did you call the dog off? They may call, if it's a criminal, a civil case, they may call an expert witness. That's someone that we retain, usually outside your agency. So we get away from the notion of bias. We don't want to bring anybody from in-house. We'll go to an outside source and hire someone, and we pay them for the time putting into that case. An expert is simply defined as someone who has more knowledge on a particular subject than the average person. But that doesn't take a whole lot. You are all expert witnesses, whether you realize it or not, because you have more knowledge than the average person in what it is you do. As a supervisor, as a trainer, as an FGO, as a supervisor, whatever it might be, you have more knowledge. So you could be considered an expert. But we'll hire somebody to come in. And the goal of the expert is to explain to the jurors what it is that's going on here. There is a debate whether they can testify as to the ultimate fact, which is, yes, this use of force is justified. Some courts don't allow the expert to say that from either side. However, you can testify to something like, I believe the actions of this canine handler were consistent with contemporary canine policies and procedures in America based on my experience and my training. Oh, okay. And then, of course, they're going to get into your background. Are you still current? You're still employed as a law enforcement officer? And then you have to know your history inside and out, from when you started, when you graduated from the academy, what your various assignments have been. If you were sheriff's department, how long did you work inside a custodial facility before you went to patrol? What training classes have you attended? How often do you attend training classes? Have you provided training in-house? Have you provided training to people outside your organization? Have you provided training within the state in which you're employed? Have you gone outside that state to provide training? So all of that goes to your recognition as an expert. Then they're going to ask you, have you written any articles regarding the subject matter? Have you written any articles? It doesn't matter if it's a USPCA K-9 Courier, or you've written articles for the National Tactical Officers Association and their newsletter, or some other IACP newsletter. Keep track of all that. Maybe you've written some local articles. Keep those and say, yes, I have written on this subject. One of the things that you're going to learn how to respond to is hypotheticals. They always love to give hypotheticals. Assuming that the suspect, when you encountered him, had his hands up, you could not see any weapons, would you be allowed to release the dog on that set of circumstances? Now, as an expert, you're not an advocate necessarily for the officer you've been hired to testify on behalf of. You have to be somewhat neutral. Again, obviously, your testimony is going to be helpful to that officer. Otherwise, we wouldn't hire you. But there are times you're going to have to concede things like, if the suspect is perfectly still, he has raised his hands, you cannot see any weapons, he says, I surrender, and there is no threat based on the hypothetical you gave me, based on those facts alone, I would agree with you, you cannot deploy a dog. I get it a lot in my shooting cases. In fact, it just happened last week on one of my SWAT shootings, where one of our police dogs, unfortunately, was killed by the suspect. And the suspect encounters three of my SWAT guys in a lethal force encounter, and we shot and killed the suspect. During the deposition of one of my shooters, they said, can you shoot someone if they're just standing there with the gun? Nothing else. Then you have to respond, is he pointing the gun at me? Is his finger on the trigger? Or is he just standing there and the gun is pointed toward the ground, his finger's not on the trigger, there's nothing else going on? If that is the case, then yes, I agree with you. I cannot shoot him at that moment. However, if there are other facts and circumstances, if there's a person on the ground who was bound somehow and he's pointing the gun at them, that's a different scenario. But get these hypotheticals, you have to sometimes flesh it out. Are you asking me this, or is it just limited to the facts you gave me? And if it's just limited to the facts as you presented them to me, then yes, that may be true. I cannot use force. But if they change it anyways, of course, your testimony is going to change. They're going to ask you about, what awareness do you have of the canine handler that you're defending? Have you ever seen them train? So if you're going to be an expert, I would advise you, go out and watch. Go to that particular department's canine unit and watch them train. Talk to the handler. I always like my experts to go out and hang out with my handlers or my SWAT guys and watch them train, talk to them, get to know them. That way, say, yes, I have seen this dog in a training scenario. This dog was very responsive to the commands. When the dog was given the out command, immediately released. Again, it may be a little different than the actual scenario. Sometimes my experts have done ride-alongs with some of my clients and are able to say, yes, I've seen them in an actual scenario, and I was very impressed with what I saw. You all also say, yes, I've reviewed the training records of this canine handler, and I find them all to be consistent with what I would expect contemporary canine handlers to be experiencing when they go through their training. You're going to have to know the policies and procedures. You're going to have to know cases, Graham versus Connor. And it's not just Graham versus Connor and the three-part analysis. What's the nature and severity of the issue? In other words, why are we there? How is this suspect an immediate threat to me and others in the area such that I need to use this level of force? And three, how is the suspect resisting arrest? Know the facts of Graham versus Connor. Know that it was a diabetic reaction taking place, and he wasn't fighting with anybody. Know those facts. I've tripped up a couple experts who talk about Graham versus Connor, and I'll say, great. Tell me about the facts of Graham versus Connor. Do you remember? No, I don't remember. You tell me. You're talking about it. You want to talk about Tennessee versus Garner? Tell me the facts of Tennessee versus Garner. They're going to throw out legal cases. Make sure you know the facts, not just a holding. You have to actually read the case. Don't rely on a summary from some website that you went to or someone told you about that maybe even heard about it in class. Look up the case yourself. Ask others, what do you think the court was saying here when they said this? You need to know the facts and the rulings of all these cases. They're going to ask you about what methodology did you use? What is your opinion based upon? I looked at the USPCA training standards. I looked at the IACP best practice for canine handling. I looked at the local post requirements for canine training. Based on my experience in training and look at these documents, I have arrived at the decision that everything that the canine handler did that day was consistent with contemporary standards for police canines. That's how it's going to come out. In federal court, we have a couple different rules. Rule 30B6. So Federal Rules of Civil Procedure, Rule 30B6. Rule 30 is depositions by oral examination. That's the overall that you get to pose. The other side gets to take up to 7 hours, not including breaks. So if it's a full 7-hour depo, anticipate you're going to be there probably 9 to 10 hours because breaks, lunch, things of that nature. It's a very long day. But going down to 30B6, that's the deposition of the person most knowledgeable. A lot of times the other side will say, we want to know about the training of your canine unit. We want to know about training of your SWAT unit. Who's the person most knowledgeable to talk about policies and procedures? Who's the person most knowledgeable about training? Who's the person most knowledgeable about tracking? Who's the person most knowledgeable regarding searches for narcotics? Who's the person most knowledgeable about searches for people? Who's the one that's most knowledgeable regarding less than lethal tools in your agency? So a PMK or person most knowledgeable deposition may encompass a couple of different individuals. So your attorney is going to have to sit down and say, who best can answer these questions? Can you answer all these? No. Who else should we prepare and have answer the remainder of those questions? So we may have 2 or 3 people from your agency. I had a trial last year on a shooting case. The other side requested our person most knowledgeable regarding training. We brought in our captain who was in charge of our training academy, and he was just absolutely outstanding. Looked the part, looked like he was a poster child for what a training captain should look like. Sharp, well-dressed, so very articulate, and was able to talk about all the training and then how our deputy followed his training and did what is expected of him based on the training that this particular organization provides to its personnel. He did a great job. I also had expert witnesses to talk about what my deputy did, but the other side wanted our person most knowledgeable. It was like having an extra expert witness without us having to pay for it. He was that good. So PMK deposition gives you a chance to come in and talk about your organization. You better know your craft. You better know your organization. And then we have the rules, FRCP Rule 26A2, which defines what an expert witness is. It tells you what you must provide in an expert witness report. State courts don't always require a report. Federal court does require a report from an expert witness, which means you have to provide certain information. How many times have you testified in the last 5 years? What cases have you testified on behalf of plaintiff or defendant? What articles or books have you written? Where have you given speeches or where have you presented? And then you list your opinions. You list all the evidence you relied upon, all the reports, all the videos, all the audio, all the dispatch, all the CAD printout, things of that nature. That complies with Rule 26A2. Becoming the expert. Once you're the expert, don't go into a field in which you're not quite certain. Stay in your lane. Know what you're good at. Make sure your credentials are all accurate. I run backgrounds on the experts that come against me. I will find out if they really do have a bachelor's degree from such and such university. Did they really teach at this course? Because I will locate people that know them and I will find that out. The other side's doing that to you as well. Maintain the records of all your training that you receive and certainly stay current in your field. Know what's going on. And whenever you get a chance to polish your skills, take advantage of that. Sit in on mock trials and have an opportunity to do that. Comes down to it, the only thing that we all have that we can never negotiate away is our integrity. They will be judging you to see what your integrity is. If we have nothing to hide, we have to trust the jury that they're going to do the right thing. We have to give them the facts and all the facts as to why they should come and act in our favor. And appreciate, this is not, testifying is not something you learn overnight. It is an arduous process. Some people are very good at it. Some are not. You have to know right from wrong. You have to know an appropriate apprehension from an inappropriate apprehension. When you can deploy, when you can't. Just because you can doesn't mean you should. Be able to provide the big picture to the jurors. That's your job as an expert. And never, ever give any incorrect information to a jury. Don't ever let them think that you're being paid to give a certain opinion. That goes back to the integrity rule. So that's how I see preparing you to testify as a witness, a PMK, person most knowledgeable, or an expert, which we use quite a bit.
I wanted to open this up to everybody that's with us today, especially our best practices. Hey guys, give me a story about how either you had to testify as an expert in your case, or perhaps you had testifying as an expert in another case. Now, I'm saying an expert in your case because feeding off of what Gene said in my experiences looking at handlers, I want to underscore the fact that the handler is an expert. So get comfortable knowing that you're the expert. Maybe somebody from our best practices group can start by telling a story, a lesson learned from a handler that you saw testifying that was effective, or maybe an error or something that could have been improved upon, maybe from an expert witness that was not part of the case, but came in after the fact. Who would like to go first, Steve?
I'll talk about the fact that if you're going to give tracking evidence for a tracking dog case, 46 out of 50 states have tracking case law in their state jurisprudence. So that means the odds are, if you're going to give tracking evidence, your sole job is to testify that the person you found was at the point where you started the track. You cannot testify to their guilt. And I can get into a story about where somebody made a mistake of doing that. You just testify that the person you found was at the point where you started the track. And for that testimony to be admissible, there are certain criteria that different states have. Generally speaking, it's that you're qualified, your dog's qualified both through training and experience, and that you started the track at a place where the circumstances indicate the guilty party to have been, and that the track was not so stale or old or contaminated to be beyond the dog's ability to follow. That's basically what most of the states are looking for. So you're then going to be asked to give an opinion about what your dog did, and that this was in the capabilities of your dog based on the nature of your training and background. I've testified about this numerous times, and every single time that we've gone through it, one of the things that happened in laying the foundation for my ability to give an opinion as an expert on my dog, the prosecuting attorneys would try to lay the foundation for my qualifications as an expert. Almost without exception, about a third of the way into the process of going through the 47 questions we had on our questionnaire to lay that foundation, the the defense attorneys would tell the judge, Your Honor, we'll stipulate to the qualifications of Deputy White or Officer White. Don't let your prosecutor be tempted to make things quick and stipulate. Because when you stipulate to those qualifications, the jurors don't get to hear all of the things that make you the expert. They don't get to hear about your awards. They don't get to hear about your experience, the bad things that have happened to you that you've learned from, the good things that you've been able to accomplish. They don't hear about the things you brought into the job before you got to the K-9 and before you maybe got to law enforcement that are relevant to the case. They don't get to hear about the special nature of your dog and how that dog was selected and why you know that you are capable of following that track to the exclusion of others. So it's very important that you get that foundation properly laid for your ability to testify. I've watched it happen before where people have accepted the stipulation and the jurors just didn't get that piece of credibility that Gene was emphasizing. The jurors want to know that you are credible. And this is a piece of it that you have to go through. I'll just leave it at that.
And thank you, Stephen. Just want to add to that because you brought something to mind. Some of the best testimony that I ever heard from dog handlers were the handlers who were not afraid to admit that they were scared, or they properly described the danger that either they or the dog were in. For example, we didn't see a final alert on the dog search for narcotics because the handler was afraid of fentanyl and the dog accidentally ingesting the dangerous drug to kill the dog. That honest testimony, or it's dark, it's 2:00 in the morning, I don't know where I am, I'm in some backyard somewhere, and we're searching for a really dangerous person, and really building the theater of the mind to describe the environment that police dog handler is in and why that dog becomes such a critical tool at that time. That is so powerful. And courtroom, I always say, is not the place for bravado. It is the place to be honest. And if you felt the hair on the back of your neck coming up, you describe it that way. Something was wrong here. Human beings understand that, especially jurors and judges. It humanizes the cop, and it brings that call into that dangerousness level that they face all the time. So, because maybe you're used to the danger, doesn't necessarily mean everybody is used to that danger. And that's why we have those dogs. Who else might want to add something to this discussion? Gene, I know I gave you a chance to drink a glass of water and catch your breath.
Let me add to that. I can't train you when you come across as human. Like Steve said, a lot of my shooting cases, all my SWAT cops, they're macho. At times, on the shooting case I had last year at this time, my deputy's being cross-examined by the other side. And they said, do you feel any remorse? He goes, I'm sorry for the family that I had to take the life of their loved one. That's not what I wanted to do. But you also have to understand what this has done to me and my family. I sit at dinner sometimes and I start crying for no reason. My family is wondering what's going on with me because I'm not talking about what's going on. He goes, so yes, I understand this has impacted the family of the decedent, but it's also impacted my family. There was not a dry eye in the courtroom, and that was not fake. That just came about because of the question he was asked, and he decided he was going to be honest and say exactly what happened. And that was powerful. We won that case. I credit my deputy for doing such a great job and testifying. So he put aside all the experts, because sometimes I think experts may cancel each other out in the minds of a jury. It comes down to you, the individual that's accused of the wrongdoing, to explain your actions. And if the jurors like you, we have a much better chance of winning.
One of the things I like most about our group meetings on Mondays is we have this ability to have these discussions. And it's just, we call it downtime and during training or time that we're not working the dog or working another dog. It's those discussions that you have with the other dog handlers and the other dog trainers that are incredibly important training time. Or when the training is done for the day and you're hanging around for another half an hour and you're still talking different types of dog things. This is what really this group is. I like most about this group. When Gene and Steve and everybody starts talking about a topic and relating their stories, which I relate to more at a personal level, and it connects with me so well. Don, go ahead.
Yes, one of the things everyone needs to understand is when you go in the courtroom, if there is no other expert there, you become the expert. and realize that nobody else in the courtroom really knows what you do. Sometimes you'll be sitting there in the witness stand and the opposing attorney will throw some words out at you and say, this happened and whatever else. And that may not have been the case. That may not have really happened. So you may have to be the teacher to explain some of the things that are happening when you use terms. What does it mean when you're tracking and your dog is doing this? You may have to give the attorneys some knowledge. I have never been in a U.S. federal court where I didn't have to talk with the attorney that I was testifying for, talk about what certain terminology is. In one case, the U.S. attorney turned around and said, after I question this witness, I'm going to take a 5-minute break and then you can tell me what he said. Yet there's a lot of terms going on. They don't understand a lot of things. Even in the lowest court, you may have to become the teacher to advise people. How does a dog learn? And the biggest one that I ran into is I'm in a court in Tennessee and the judge says, will somebody please explain to me how narcotics can be in the car, they're taken out, but the dog can still find them. That's residual odor, is what we're talking about, volatile organic compound. So you had to explain that to him. Once I explained how dogs learn, he says, I've never had as much information about how a police K-9 works. And thank you for that. I will always remember that. So there's a lot of things that go along with being an expert witness. Sometimes you have to educate the people that around you, the jury, the judge, the attorneys, and tell them what actually happened during your deployment. Thank you, Luke.
Yeah, right on. And you bring up a point because I think it was at the very last meeting, we were talking about the importance of having 1 or 2 attorneys in the county attorney level or municipal attorneys who specialize in canine cases, who have a little bit more knowledge about the average canine case. And those would be the attorneys who generally would be going to trial on your cases because they've received specialized attention. And I know Gene goes around teaching various attorneys, prosecuting attorneys on how to best represent their police department K-9's case and how important that is.
A canine handler who I had never met before. The very first case I had when I left the LA County District Attorney's office to go to a private law firm, my first case was a canine case. And that canine handler showed up to my office unannounced with his dog. And he comes into my office and says, you don't know me, I don't know you, but you're not going to screw up my career because you don't know what you're doing. He took it upon himself to take me to training, ride-alongs. I took bites, and I became very active in the canine community, particularly through LA County, hanging out with the canine guys and learning their craft. Because I can't cross-examine an expert witness against my handler unless I know the terminology. When we're going to use a 6-foot lead versus a 30-foot lead, Schutzen versus KNPV and all of that. You've got to know that stuff so you can effectively cross-examine the other side's experts, which means everybody here, if you're going to be sued and you're going to have an attorney represent you, take it upon yourself to teach them and educate them. And this is not something you're going to learn in a couple hours. I've been doing this, almost 40 years, and I'm still not understanding everything.
None of us are.
And I see Melinda added in the chat room how she has like attorney ride-alongs, so to speak, for lack of a better word. She does attorney ride-alongs where attorneys come out to the training area to watch the scenario, and then it breaks out into different types of testimony. It becomes a teachable moment, right? We're immersing people into our environment to make them better understand what we are going through, the training we are going through, how we are deploying the dogs, so that they know how to ask questions better of us in the courtroom. But we also need to be very prepared to answer those questions professionally, honestly, and understand some of the traps that some of the other attorneys are trying to lay for us to catch us in those moments. And our next parts are going to be talking about some of those traps and how we can be deposed in a better manner, how we can survive those different types of cross-examination. Scott Sargent, I see you're on board here, and I'd like to come to you at some point because I really want to pick on some of your experiences here about you going across the country and having to help these different departments that are going through some serious crisis and rehabbing them, or at least advising them on how they can improve upon not just their department, but also upon their canine units. And perhaps you find some linkage between these different canine units that might be failing that might be improved with the ability of the dog handlers to testify better. Sometimes it's not the case that's bad. It's just the way it's getting presented is bad. And, how we can avoid some of those pitfalls. So I know you're just coming on board. I don't want to catch you completely off guard and give you a second or two to prepare on something like that. Thank you, Mel, for bringing that idea.
I'm a policy guy. Policies are essential to know and to be able to repeat in court. If the primary elements of Graham, that's great. But remember, there are usually supplemental factors in your policy that speak to mental illness and de-escalation. What other factors within your use of force policy that comprise Graham were present during that event that you could speak to? And you really need to know how anything in that policy could be used by the other side to, wait a minute, doesn't your factor say that you should consider degree of mental illness or degree of intoxication? Isn't that part of the policy? You should at least be able to dismiss it. Yeah, I'm familiar with the policy, and those 4 or 5 additional supplemental factors are to be considered when they're present or relevant. In this case, they were not. Know that they're going to go through your policy as much as your side is, and so you should know where that is. Also, just real quick, a couple of things. De-escalation and proportionality are 2 concepts that are relatively new to the conversation about police use of force over the past few years. While there's some mandates out there that departments implement these de-escalation policies and make sure that force is, in addition to everything else, proportional to the resistance, a lot of agencies do not have formal de-escalation policies. They talk about it, it's part of the training, and maybe they'll have a conversation about it, or maybe it's a new policy separate from use of force, but you need to know what that policy is or what those concepts are, because they're going to talk about the importance of de-escalation. So the White House put out a document years ago that required all police departments to implement de-escalation training. Do you know what it is? How does it work? And in this particular case, how did it come into play into your dog bite? And there's a chance that you will say, well, that was over by the time I got there. I got briefed, deployed the dog, and this, that, and the other thing. So the entire picture comes into play. What were you briefed? What do you know about this suspect that's outstanding in the backyard? What de-escalation techniques have been used so far to date before you got there? And when you got up on it, what did you do, not do? And what other kind of conversations do you want to talk about with that? So just make sure you're aware of that. Proportionality are questions that have not come up before. You tell me about a bite with respect to the proportionality of the resistance. At what point did the guy objectively give up or throw the weapon down? Those are things that I think in the future, nuanced policies are going to start making their way into courtrooms a little bit more. Everybody needs to know how to answer those questions. So I'll leave it at that for now. Those are things I think that might help in preparing to testify.
Okay, let me bring up a point because he jogged my memory on something. I remember, Gene, you were talking about the Fourth Amendment. How many times have you learned about the Fourth Amendment? And you went back to the police academy days. I heard Chief Donnell and Captain Kerwick and Sergeant Green talking to me in the background, going, scenario-based training, Lou, scenario-based training. And imagine if we could testify that every training session, we have to first start with a Fourth Amendment issue. Is it a justified search? Imagine if we could testify to that. Every time we train our dogs, whether it's use of force because an apprehension is a Fourth Amendment issue, or if it's a search for narcotics or explosives. Imagine if all the scenarios that we went through, if the trainer simply asked, was that a justifiable search according to our policy, to Scott's point, according to constitutional grounds, things of that nature. Powerful stuff that we're already doing it, right? We just need to add a little component to it or be able to testify to that to show that every single time we're doing this, the trainer requires us to say, is this a justifiable Fourth Amendment issue or not? That would be pretty powerful training. Who else would like to add? Go ahead, Don.
Lou, I think it's important that supervisors understand that it's part of their responsibility to look at the report that someone has written at an action to make sure that everything is there that needs to be there when they go to court. I know sometimes, myself included, when I was working You get all wrapped up in what just happened. You're excited, you're this, you're that, and then you go on to write the report and you're still pumped up and amped up and you don't write the best report. And I think it's always good, especially on those types of cases, that a supervisor makes sure that the elements needed for that report are in that report. To your point, I think Dave Green had an excellent thing from Raleigh where he was telling people what made you think that you could deploy the dog into that under those situations, and testing the people, making sure they understand things like that.
Anyway, I want to talk generally to the audience that is coming on board, especially you trainers. Come up with a couple ideas that you might do in training that might incorporate future testimony or help prepare a handler for future testimony or a deposition or a report writing. What do you do in your training on the field or in the classroom? What are some good ideas? Because report writing is not the most exciting of things, but it can really be. Melinda, you have an idea. Go ahead.
Thanks, Lou. I bring the attorney or an assistant attorney in to be there during a scenario. It could be a drug scenario. It could be a bite scenario. And the handler does not know that they're there for another specific purpose, which is to deconstruct it as if it were a courtroom setting. Typically, the new handlers don't know what's coming. The rest of them know. But also policy, department policy and legal, we will often break down every scenario, whether it's before, during, or after. Sometimes I'll stop them when they're standing there with a leash in their hand and a barking dog at the end of it and say, rattle them off. I need to hear the Graham versus Connor. I need to hear this case, that case. If they can remember that stuff while they're standing there stressed out over what they're about to do with their dog, I figure then they should be good to go, maybe in a courtroom setting because of the stress that's involved in thinking of it. And I'll stand there and, come on, we're waiting. We got to go. We got to go, and put that pressure on them. It's just another way of adding a little bit of realistic, such as it is, realistic pressure to the training. Thanks, guys.
Yeah, right on. Anybody else want to comment on maybe some field training ideas to help us better prepare for testimony, report writing, things like that? What do you want to share? How are you doing this in the field to make a better impact with our handlers that you might want to share?
Let me add this. I've been working with the Secret Service and their patrol dog program since 9/11. And one of the things that they like to do is when I come out, we spend the day learning how to testify. I'll show a video. I'll ask everyone in the room to write a report. I'll review those reports that evening. And then the next day, I put them up there and we do some mock cross-examinations. Then I'll bring in their supervisors and I'll mock cross-examine them. And I've had some of them admitting to civil rights violations without realizing it because they don't know their policy. They're not out there watching the training. How can you supervise if you're not out there? So just doing these mocks, everybody realizes, oh my gosh, we have a lot to learn and there's ways to do it without breaking the bank. Maybe get your local prosecutor or your local city attorney or county attorney represent your agency. Said, we would like a day of training. We will provide you with a body-worn camera video of an apprehension and spend 2 days with it, or 1 day, whatever time you can get, and say, just run us through some mock examination and let's see how we do. If you learn that one of your fellow K-9 handlers in your area is on trial, go watch. That's the best way. So you're not the one up on the hot stand, but you can watch someone else being grilled and you'll say, yeah, I'll answer it that way. Ooh, I wouldn't answer it that way. That's another way to learn. There are opportunities out there, but you really have to look for them and make them happen.
Gene, while I got you, can I ask you this question as we're closing out here? I have heard some police officers are getting in a jam when they're testifying with the question of, did you review the body-worn cameras before you wrote the report, or did you write the report before you looked at the cameras? Can you give us a little advice on the pros and cons of either, your experiences, or is it a big deal or not?
People like to make it a big deal, particularly, let's say it's an officer-involved shooting or deputy-involved shooting. And the old school was, we're going to question you regarding state of mind, and we're not going to show you the video. And you're setting people up for failure. I hate that. I prefer let our officers or deputies who are involved in a critical incident review the video. And sometimes it refreshes memory, sometimes it doesn't, and then ask the question. So if you have an apprehension, you better review that video before you write your report. And then after you write the report, you better review the video again. Because if you're wrong in any way and the other side finds it, your potential Brady material, if they think that you intentionally lied about something or misrepresented something, they're going to come after you hard. Why would you put yourself in that position? Watch that video a million times because you're going to see things differently every time. And you better make sure your report comports to what is inside that video, or you're setting yourself up for a world of hurt.
I'd like to add a little something to what Gene just said, and it ties into John Sakamoto's question that I'll bring up a little bit later. But one of the things that the advantage to looking at the video as you're writing your report is that you're going to see things that the camera had a different perspective of than you did when you were taking action. You can reasonably expect somebody will see that discrepancy, and it's your job at that point to say, this is what was in my head. This is what was in my field of view at that time. If, for example, at the moment when my camera was facing this, I'm looking over here to my left, then at that point, I'm seeing something completely different that is now affecting my decision-making. So we have to realize that we've been all taught, keep your head on a swivel. The camera, particularly if it's chest mounted, is not on that same swivel as your head. So it's an important thing that we have to make adjustments based on what we actually saw as opposed to what the camera sees.
I'm thinking actually it's not a bad idea to have a preface for your report. Say the body worn camera sees things in 2-dimension or we see things in 3-dimension. There are things that I will see that the camera will not capture, and likewise, the camera will capture things that I may not have seen. And so therefore, you have to combine my body worn camera video analysis with what I recall in other facts and circumstances, because we spend a lot of time explaining to jurors how to review body worn cameras. And sometimes my experts have to come and explain, listen, it is a tool in the overall investigation. It is not the tool because there are issues, and you have to take that into account when you're conducting these investigations.
Yeah, point on that, Gene, too. I think it's interesting to note that every time you take your dog out, every officer on the street turns around and looks at you. And by doing that, their cameras are on you. When your camera shows some fault, you should check the other cameras because they'll all get it.
Which is why you can't have inappropriate morale patches anywhere on your uniform, which is why you cannot be using 4-letter words, because someone is going to capture it and someone's going to try to use it against you. So yes, when you turn on that camera, everybody, it's game on and you have to act like.
So, Gene, someone's got a blemish in their past, meaning that they posted something when they were in college that probably they're not proud of today. And that comes up in their testimony to try to impeach their credibility or at least their professionalism. Or there's something that has happened that is come up now in either a deposition or at the trial level itself that the handler is no longer proud of, but yet it's part of their life and it never goes away. Some advice on this?
Yeah, it's happened to me, except my client didn't tell me that there was bad stuff out there. The other side found it because they had a law enforcement officer who was a relative of the person we shot and killed. And that person was doing a lot of digging and found some stuff that my client, even though I asked, is there anything out there on the internet that I need to be concerned about? Oh, no, sir, there's nothing there. And then I found out he was posting some pretty bad stuff on a law enforcement website that the relative of the decedent had access to. It caused us to have to settle the case. It caused him to undergo an internal affairs investigation, and he ultimately was relieved of duty. So I always ask up front, if there's anything out there that's going to harm us, you got to let me know so we can prepare for it. One, we could either try to do a motion, let me do exclude at time of trial, or it pops up during deposition. We have to be able to deal with it. Say, yeah, I was 18 at the time. I was stupid. I didn't know what I was thinking. And certainly I've done everything in my career since then to overcome that and blah, blah, blah. All we could do is try to explain, and then open time of trial, we'd bring a motion, try to exclude it. If it had nothing to do with the incident, it's remote in time. It's 10 years old. It's 8 years old. It has no bearing on this. You weren't even a law enforcement officer at the time. We have to take all of that into consideration.
So it's recoverable. And I guess my point that I want to make is we're not going to hide it. We're not going to lie about it. We're just going to admit it was the mistake, and it's recoverable type of stuff. So don't let the cover up be worse than the crime, so to speak. This question I bring out to those who train with other groups of dogs that are not part of their own agency and may be operating off of different policies. So how do you set up your scenarios so that they are maybe universal or specific to the agencies training with you, because not all the policies are alike? How do you testify? Second part of that question. If you were testifying as a witness or as a trainer, how would you testify to a policy that is not yours, that you might have trained something different because you trained to your policy, you didn't train to theirs, I guess is my point. So my question overall is, what do you do to tailor your training to that individual department? And two, what happens if you inadvertently train a different policy into a dog team?
Give me the beginning of that part.
I'm going to give you the beginning. So the first part was, how do you tailor your training so that it's not so general, that it's vanilla, but yet it's specific to Department X that might be training with
Okay.
Department Y?
Okay. So
First part.
we've covered this as part of the best practice working group. You train to your tactics. Whatever your department's tactical playbook is, that's what you should train to. And that may differ than your state certification standards, your K-9 organization's certification standards like the USPCA and others. Nonetheless, your department's going to dictate what your training should be. And if you go to outside training and they train something different to show you something new, you think about how can we incorporate and apply it within our body of tactics. But don't just put it there without checking to make sure that it complies. That's the big thing, is always train to tactics every time. That is the mission.
Thank you for that. Anybody want to add to this? Yes, sir. Go ahead, Chris.
We did some training in some outside agencies, most of them being smaller, and they come train with us. And it's exactly what Steve said. We have our way of training, our tactics, the way we do it. They sign a waiver when they train with us at the beginning, and anything they may not be comfortable with or whatever, we'll talk about it. But we trained our tactics, our policy, and that's all we can do. But we're more than open to having other agencies come train with us, mostly smaller agencies.
To tie this in, because this is the second time I've mentioned his name, John Sakamoto threw a question up in the chat. Long story short, he was talking about the difference between the scope of Canine teams when deployed for administrative searches versus PC searches. There are now times where we're called upon to take action based upon Canine teams that are not our own. So as a police officer now, so this is the wrong audience for this, because we're the Canine officers who other people are going to have to take action based on us. But does anybody see anything that specifically relates to John's question about searches from third party, like consultants, the security teams at stadiums and things like that, TSA's third party cargo, things like that, and how that couples with us? It's outside the scope of the topic today, except for the fact that those people may get brought into our case. For example, when I handled an explosive dog as a secondary employment position, I discovered what we thought might be a device one day. The local department came in and they had to take action based on what I did. So now we've got this confluence of people who are in different capacities.
Steve, the idea that the Democratic and Republican national conventions are exactly that. There are people that come in, bomb dog people that come in from all over the United States, and they're from different organizations, federal, local, and they go searching all over the place. And if they find something, of course, they have to act on it because it's explosive. What happens if you go to court from that? I think it's a question.
Right. And I've never had to. I don't know many people who have.
When I worked at ATF, that's exactly what we did. We practiced with those people before they went to the conventions, and they're from everywhere. Not only is the Secret Service and ATF involved, sometimes it's the idea that these people are on the outside looking for different things. Once they found a gun in a trash can, they have to act on it. That's all I can tell you about that. But after that, if there's an arrest, what happens then? How do we go to court with that? They're going to go to court.
Yeah, I think that's just, Gene, my thought was you would probably have a better handle on this than others, but that for all intents and purposes, when you have these joint operations or you have this interplay between agencies, the prosecutor's going to have to get together and sort that out about who's going to be testifying to what. And that basically we can't do anything except stay in our individual lane, our policy, our tactics, our approach. And yes, they gave us this information, but we each testify about what we do, right?
Let's say your agency's called to look for a suspect in a hospital complex, and that hospital complex has their own K-9. And you're short personnel, you don't have a K-9 unit, but you send patrol personnel there and they use the hospital's dog to locate and there's a bite involved. Well, that hospital, because it's private security, doesn't have to respond to any Fourth Amendment issues. Their training may be completely different. That bite may not have occurred under your policy, but under their policy, it's okay. Yeah, there's a myriad of issues that could arise from a situation such as that.
So then it's important to have a mutual aid understanding and the proper incident command between the agencies running things and decide who's going to take responsibility for the actions of all parties concerned.
There should be written memorandums of understanding if you're going to use a non-law enforcement resource like a hospital K-9 to assist you. Yes, and it has to be thought out in advance.
Sergeant Green.
Don't put that on me. I'm just Dave.
All right, Dave.
Forgive me. I'm a little under the weather, but the remarks that I have for this, worked a bomb dog in a military capacity on duty and as well third party contractual. And when I'm on duty as a Raleigh police officer, we generally will use those third party K-9 alerts or whatever as a informant type information that we can corroborate and that we recognize them as a source that we will then dig deeper into. There's
Right.
a lot of, when it's let's just say the arena where an NHL team plays, there's a lot of unwritten contracts when buying that ticket of volunteerism for searches, etc. We get let's say a person-born dog gets an alert on a person. We seclude them as if it's a worst case scenario, but then we quickly go into a volunteer state of mind, if you will. I think, does that kind of cover how this conversation? A lot of it
Chip
is.
into the chat, John.
I think so. John, if you could give me some feedback on some of the answers you have heard in the chat again to let us know if these guys are hitting the mark. And so he follows up with, I meant if called into court is his follow-up question. He understands the MOU and so on. I think he's looking for the testimony and called into court. How do you guys address?
I think Dave just handled it. Dave just handled it. That essentially they are delivering a piece of information that may be a little more credible than if it came from somebody else, but their credibility is going to have to be established with the courts separately. That's going to have to be a piece later on that's woven together by the prosecutors.
And clearly courts will recognize an informant that gives their name, gives corroborating information. I think we follow along those lines.
While we're waiting for John on that answer, Gene, the next part you're going to be talking about general rules, depositions, cross-examinations, and things like that. This webinar was designed to get us going on making the handler trainer understand that they are an expert, get comfortable with that. Some of the documents that you need to enhance and justify that position as a canine handler, the records and things like that, how to polish our skills, trusting the jury, trusting the system, things of that nature. All good general advice. But before we leave off, the piece between the training, the call, and now the preparation for trial are those records and those reports. I would like you to just underscore once again the importance of the records, the importance of the report, things that those pieces, those documents underscore again why that is important and what pieces need to be part of that.
Well, record the apprehension reports. There may be an allegation in a civil case. I'm referring to a civil case now where they're seeking monetary damages because you injured somebody under federal or state law. And there is a element of the lawsuit referred to as a Manel, which deals with policies, practices, habits, and customs. And it's either they're saying that you're well trained, you're not well trained, you failed to supervise, you failed to train, those things. So we want to be able to show that you are well trained. So the training records, and you have training calendar for what you're going to be covering for the past year or 2 years and year forward, and who's attending those training. What are you training? If something changes, did you document that the training changed? You went from building searches to area searches. Who was there? Who didn't show up? Who had to leave early? So we can track who's doing things and what supervisors were there. And who are your trainers? Are they in-house? Okay, what's their background or training? Are you bringing in outside consultants? What's their background and training? Because all of that's going to be explored.
Right on. So John has added on, and let me read his post. We can answer his question. This is don't meet the 5-year experience requirement. What he's put in for those who can't read the chat is case law to qualify as a sworn law enforcement officer. For example, licensed engineers in some states, when deputized, even if only temporarily, are considered a limited peace officer or a sworn law enforcement officer for the purposes of offering hearsay testimony, because they were licensed in their area of expertise for at least 5 years, even if only sworn for part of that 5 years. That's his follow-up.
I think this is, again, going to boil down to, if we're going to stick to the topic that we're talking about here about courtroom testimony, it's all going to boil down to your pretrial workup. Your prosecutor, your defense attorney, whoever's representing you on whatever kind of case it is, going to have to establish whether anybody, whether it's another handler for a private agency or another agency, is adequately qualified to give the kind of testimony they're going to give. If not, then they may not be giving expert testimony, but they could still give direct testimony.
Anybody else want to make a comment to this? John follows up, saying when a third-party handler offers hearsay, if they aren't backed up by a sworn K-9 handler or a proper MOU. Apparently, he says it happens a lot in his experience in his area. I guess that's our best advice. Listen, I get geeked out over things like this. I love the webinars. I love meeting with you guys. I get just energized by listening to you. What do we have? 50 people, 55 people in this webinar. I don't know how many hundreds of years of experience that collectively brings us together through networking and sharing advice back and forth to each other. Gene, I am looking forward to your next 2 parts. The next one, Don, as soon as you get the date for us in March, I'm looking forward to us all meeting again. And like I said, don't forget, guys, to put down your time for this training block. Don't forget to get that terminology handout that Don has sent out to everyone. If anybody has any last words, I'll leave it to that. Don, I'll let you close out this USPCA webinar.
Thanks, Lou. Thank you, Gene, for everything. It was really good. And not surprisingly, you did well. I think the idea that 87 people signed up for this, and while they all couldn't all show, tells me this is a topic of great interest to many people. And I think we should pursue this and make sure everybody understands what is expected of them when they go to court. I think that next time when we get into the nitty-gritty of depositions and everything, it'll start to sort itself out really well and understand exactly what an expert is and what you need to do, what you need to know. And I thank everybody for coming and hope to see you next time.
Thank you all
Thank you.
for what you did.
Thank you, Gene, very much.
Well done, Lou. Thank you.
Guys, thank you
Good
all.
job, guys.